Let us examine the eSign documents in this ADR process. As e-contracts have become a staple of today's commerce world, synchronizing the operational framework of the e-contracts with the legal requirements of dispute resolution mechanism assumes significance. Arbitration is a preferred mode of dispute resolution in e-commerce for various reasons of flexibility, of forum facilitation in the cross-border dealings, and swift settlement while avoiding the risk of litigation. It therefore becomes essential to ensure that the arbitration clause in an e-contract meets all the requirements of enforceability, both by assessing it from the point of view of international agreements that set out rules relating to arbitration, as well as the legal systems of different countries and their individual requirements. In ensuring the validity of the arbitral clause, the user has to be satisfied on two accounts. Whether the electronic contractual process really allows for the informed consent of the parties, and secondly, whether such a clause meets the requirement of a written one. Some answers are to be found in the international frameworks that have been developed to deal with such anticipated hurdles. The UNCITRAL model law on electronic commerce has given consideration to possibilities of dealing with impediments to the use of electronic commerce posed by the requirement in the national news laws. This model law stresses on functional equivalent approach, which is based on analysis of how the purposes or functions of the traditional paper-based requirements could be fulfilled with the use of the electronic techniques. In India, Section 7 of the Arbitration and Conciliation Act 1996 requires that a valid arbitration agreement be in writing. However, Section 7 does further clarify that an agreement would be considered as having been in writing if it has been communicated through an electronic means. While the term electronic means has remained undefined, even post the Arbitration and Conciliation Amendment Act of 2015, Section 10A of the IT Act comes to aid as it gives validity to contracts which are formed through the electronic means. Most recently, in the wake of the COVID pandemic, and international arbitration institutions have formulated fresh protocols to keep the wheels of dispute resolution running while ensuring the need for social distancing. And many have seen embracing and giving official recognition to the electronic modes of the arbitration agreements and awards. The International Chamber of Commerce, in its guidance note, has provided for certain procedural tools in reference to the continuing operations in the post-COVID world order. One such tool is set out in Section 15, which provides for the possibility for the parties to agree that the process of signature and service of the award is done electronically, obviously subject to respective national laws that may be applicable. If we turn to mediation, I was party to a recent webinar on this issue where the concerned government departments are seriously concerned with the possibility of more disputes arising in the post-COVID phenomena, and how, whether it's the government entities or the banks or others, can help in solving these problems quickly through an online mechanism and giving a greater central force to a process of mediation followed by arbitration. So, though India has largely been in the sphere of opt-in mediation, where parties have to voluntarily give consent, the other line of possibility is the opt-out mediation, where you must first almost be compelled to at least participate, though conclusion of the mediation is not something which can be forecast. So you have amendments to the Consumer Act, to the Commercial Core Act bringing forth. And there is a serious concern now being expressed that possibly we need a centralized mediation act, to which I may say the MCPC of the Supreme Court is also concerned as set up committees. So all of us are concerned with providing an expeditious remedy in this post-COVID phenomena, because otherwise in the overburdened legal systems which we have, we will certainly see a great expansion of the commercial litigation. And my personal belief is that such online mediations or settlements or processes, not spreading the net too wide initially, should be concentrated on seeing that the online, these processes are utilized for the post-COVID disputes at the first instance, so that they don't become another backlog in the system which you already have. And those can be resolved expeditiously. Of course, not taking away from the fact that all these processes are good even for the pending disputes or in other contracts which may be in question. Therefore, the current situation arising out of the COVID-19 pandemic provides an added impetus to facilitate the electronic modes of functioning and dispute resolution, and a justice delivery system around the world goes online. The predicament we all now face is unique, but it is also an opportunity for us to leverage the technology that has for long been at our disposal. The legal field has been so far not so fast to adopt technology as some of the other fields. But I think we are, the situation and the circumstances are forcing us to do this. So the time is ripe for initiating a dialogue and bringing attention to the opportunity that lies at the intersection of law and technology. I thus applaud the effort being made today to facilitate a wholesome understanding of the legal framework of e-contracts and e-signs. I'm certain it will go a long way to paving the path for a robust legal regime that is equipped to deal with the challenges of future. And as the American President John F. Kennedy once said, change is the law of life, and those who look only to the past and the present are certain to miss the future. Thank you for this opportunity.